So the tenant has appealed from the justice court. Now you're in front of the county court judge. And the matter is set for trial, and the procedure is a little bit different. The justice court moved very quickly. It's a simple process, but the county court is going to require a few extra steps. In fact, you may require an attorney based on the way that you are filed. Now, the Texas Property Code allows a non-attorney to represent a landlord in an eviction filing in the justice court, but that is not true in the county court. The county court will not allow a non-attorney to represent an LLC or a corporation or a limited partnership or a landlord who is not present at the time of the trial. So in many cases in the justice court, a representative of the landlord will appear on their behalf. Maybe it's a property manager, or maybe it's somebody who is a relative even of the landlord. They're allowed to appear in the justice court and present the case. However, on appeal in front of the county court, you may run into complications depending on how the property is owned, how it's managed, and who is necessary to testify before the court. If you have questions as to whether or not you are ready to present your case at trial, contact a licensed Texas real estate attorney. So the exhibits that you present, over and over and over, we go to trial in the county courts and we see landlords who show up. Now, maybe they don't need an attorney because they're suing in their own name personally, and you can represent yourself all the way up to the Supreme Court. If you are the party who is presenting your case, you have every right to do that. But what some landlords are not aware of is how to present their case on the county court. They expect the procedure to run just as smoothly as it did in the justice court, and unfortunately the rules are slightly different. Along with not being able to mention anything that happened in the justice court, a landlord must prepare exhibits for the case file. These exhibits are entered into the case because sometimes these cases are appealed once again. We'll talk about that a little more later. But these exhibits are necessary in the event that the judgment is challenged. If you have not prepared your exhibits, you may find yourself in a situation where the court is saying you're not entitled to a judgment. And they may give you the opportunity to reset your trial date and come again at a later time. But sometimes the court will simply dismiss your case and require you to start the entire process over. That's a harsh penalty for not showing up prepared to present your case at trial. Please be prepared. It's important to have all of your exhibits ready and all of your testimony ready, including all of the necessary witnesses. I'll give you a case in point where this is important. Sometimes a landlord will have a staff member serve the notice to vacate. Well, on the day of trial, if the landlord shows up alone and the tenant says, I was never served notice to vacate, and I've never seen this person before, the landlord. And so the landlord will proceed and say, well, here's a copy of the notice to vacate that was delivered. And the tenant might say, I never got a copy of that. And the judge may ask straight out, did you deliver this notice? You say, no, but my staff member did. Well, the first thing that you can be told is, unless that staff member is here to testify, there's no evidence that that notice was ever delivered. Remember, the notice to vacate was one of the early steps in the process. And if that step is not correct when you are here, presumably at the finish line, ready to wrap this case up, you went through the justice court, you're now on appeal, you've prepared for trial, and you have your exhibit, but you don't have anybody to testify to it, you could lose on that day and be forced to start the entire process over. Make sure that you are prepared to present your case on appeal in front of the county court. How is evidence presented? Well, The rules are rules that are established and known quite well to attorneys like myself. However, these are not things that are generally familiar to the average landlord. If you have a question about the way that evidence is presented, the way that witnesses are called, the kinds of objections that can be made to evidence that is improperly presented to the court or to testimony that is improperly presented to the court, you probably need to contact a licensed real estate attorney for advice on how to prepare evidence, how to present evidence, how to prepare exhibits, and how to establish your case before the court. You are strongly urged to call an attorney. Finally, you may hear a term referred to as trial de novo. And what trial de novo is a trial from scratch, from start, a new trial. And so I've mentioned this in other videos, and I mentioned this before, that the procedure that happened in the Justice Court is not recorded. And so many times landlords will point to the things that happened in the Justice Court, and the judge in the county court will say over and over, what happened in Justice Court doesn't matter. You are here in a trial de novo. And so the mindset that we recommend to clients in these cases is pretend like that session didn't happen. Pretend as though this is the first time that these facts are being presented and build your case accordingly. And so if you're unsure what a trial de novo is, it is simply this. You are starting from scratch. For purposes of trial, begin as though you've never presented these facts before, you've never presented this evidence before, you've never questioned this witness before. Start from scratch, present all the relevant evidence to the court, and you should be fine. Now, as far as the judgment, it is necessary to prove, if you're asking for unpaid rent, the amount of rent that is owed. This is going to require, as we've stated in previous videos, a proper accounting. If your accounting is clear, your evidence should be clear. I've seen so many cases where a landlord will show up and the judge asks him a very simple question. How much money is owed in rent? And the landlord will lean back and say, well, I think, and boom, they're shot. If you are not prepared, if you don't know your facts, you've lost credibility with the court. Don't go up to the court and figure it out. Show up already knowing precisely what you're going to talk about. If you cannot do that, I don't suggest standing in front of the judge. Make sure you're ready from the start to present evidence. Have a precise number in mind. Know precisely when the last amount of rent was paid and to which month that payment was applied. Then present what is still owed for each month leading up to the day of trial to the court. In that way, you should secure a proper judgment award for the unpaid rent. How do you get funds from the registry? Well, sometimes the funds that were paid into the registry are present for the court to award on the day of trial. And sometimes, once you go and you successfully win a trial, the court can award those funds to you right then and there. Generally speaking, we tell clients that you can wait anywhere from 2 to 4 weeks for the county registry to send the funds to you by mail. But sometimes those funds are not there. They sometimes get lost in limbo. They've been paid, the court has some record of them, but they're not in the court's registry yet. You may be in a position where you need to later file a motion for the court to disperse those funds. How do you do that? Well, again, if you're unfamiliar with that process, contact a real estate attorney. We know how to file a proper motion, how to set it before the court, and how to have the court award those fees to you. If we can't do it at the time of trial, there are procedures in place for doing it at some later date. In fact, if you have an old judgment and you know that there are funds in the registry from a prior case, motions can be filed right now to petition the court to have those funds released to you. If you need help with that, feel free to contact us at our office. As far as the writ date, that's also something that you want set with the court. Now you're going to find that sometimes the court has a little bit of latitude with that date. Rule of thumb is 6 days. And so if you're going to request a writ date from a court, measure it out 6 days from the date of the trial. Generally speaking, the court will award that. As far as setting the appeal bond, we suggest that the highest possible appeal bond be established before the court. What is the highest possible and most appropriate appeal bond to be set in your case? That's a fact issue that should be reviewed by a licensed attorney if you have a question and you're not certain what that amount is. We typically like to set the highest bond amount in order to make it prohibitive for the tenant to appeal one more time. And so the plain hard truth is, yes, a tenant does technically have one additional appeal before the Texas Courts of Appeal. However, we so rarely see a successful appeal, number one, because we always establish a super high supersedious bond. And number two, most of the time tenants don't know how to adequately file this kind of appeal, and because of that, their appeal cases are dismissed. We have seen successful filing of appeals. That process is a separate process. It is something that I believe a landlord on his or her own should not tackle on his or her own. Seek legal counsel for a little bit of advice on that process. The facts and the law application in these kinds of appeals are very narrowly tailored to what's going on in that case, and it's difficult to talk about that in a general sense in this kind of video. But understand that it is possible if the appeal is for a residential tenancy. If it's for a commercial tenancy, it's simply not possible for another appeal to ensue beyond the county court. And so really that risk only exists for a residential tenant, and that risk only exists if a residential tenant is willing and able to pay a supersedious bond that, if we're handling the matter, is set at the highest possible rate. Again, that is such a rare occasion that I'm not actually making a video for the appeal because it just doesn't happen that often. We work effectively to get land back to a landlord. And so that includes each of the processes that we've discussed. And my guess is that after having reviewed the videos that we've produced, you may still have a question or two. You may find out that you came to a question based on something that I've said or something that I've raised that you never would have considered before. If that's the case, we welcome you reaching out to us either by telephone or by email. Come check us out online at our website. Any questions you have, we're happy to answer for you. Thanks so much.